Hey, it's Al Spiegel from the McLario firm, and we are continuing our four-part series on legal matters affecting graduates, whether it's a high school graduate or a college graduate. These are legal matters affecting people in their late teens into their 20s. And today is part three of that series, and we're talking about should you buy property for your recent college graduate? And obviously, this isn't talking about, you know, a college ring or a present or anything like that, but we're talking about significant property and whether you should be buying significant property for that graduate as part of your estate plan. Sometimes people think about divesting their assets, wanting to get things out of their name, and one of the ways to do that is put into the name of a young person. And there are pluses and minuses of that. And as you can imagine, they are all very individually specific. So if you are considering any kind of significant gift to a college graduate or someone in their 20s, consult with your financial folks and your legal folks to make sure that's a good idea. But I'm going to give you a couple of pluses and minuses. On the plus side, people in their teens and early 20s typically make less money than those of us who are a little older, so they are typically in a lower tax rate. So if the property you're considering buying for them produces income, you may save tax money overall because they'll be paying less tax on the same income than you would have. And then the second major positive is that, like we talked about, by putting things in the name of a college grad, it won't be in your name. So it'll be protected in the event of any kind of a lawsuit or any kind of nursing home care needs that you might have. It won't be counted as your asset. So that's on the positive side. On the negative side, first of all, when we talk about people in their teens and early 20s, those folks are not always great money managers. Not a statement that's applicable to everybody, but it's a statement that's pretty generally applicable in that age bracket. So once you put that property in their name, they're in charge of it, and they can turn around and sell it. They can use it as they wish. They can devalue it by making poor decisions about it, and you as the non-owner won't have anything to say about it. And then the second negative, sort of along similar lines, is when you put something in the name of someone else, it's subject to whatever might happen to them. So if you're talking about someone in their early 20s, if they make a bad marriage decision and end up in a bad marriage that either ends in divorce or results in a lot of reckless spending or poor financial decisions, maybe leading to bankruptcy, maybe a lot of creditors hanging around, whatever property you put in their name is going to be subject to all that. So that's a big problem. So divorce, bankruptcy, we worry about as far as how people are going to spend it. So those are some things to think about before you put property in the name of a teen or 20 something. Not always a bad idea, sometimes a bad idea, and you're going to want to consult with an attorney and a financial advisor before you make any significant decisions like that. Again, my name is Al Spiegel from the McLario firm. You can reach me at 262-251-4210, or you can email me at al@mclario.com. God bless, and please follow up with any questions.